Donald Trump is a genuine threat to this nation. He's a threat to our freedom. He's a threat to our democracy. He's literally a threat for everything America stands for. Look, he doesn't understand what I think all of you do. America is the finest, the most unique nation in the world.
Hi again, everyone. It's now 5 o'clock in the East. Still feeling the aftershocks of last night's debate. The country now refocusing its attention on the hugely consequential choice before it in November. No matter what anyone thinks of last night's debate, if they happen to watch it or either the candidates, what is unchanged at this hour is that November's election is a fundamental, unprecedented choice between drastically different ideologies and visions for the future of this country, whether it remains a democracy. A choice between just that, democracy versus a slide toward autocracy. Voters cannot forget how the Republican presumptive nominee incited a deadly insurrection, how he cozies up to and flatters autocrats while pushing forward an agenda that replicates theirs, and who has no respect for the rule of law in America. Underscoring the stakes of the election in November even further, newly released decisions by the U.S. Supreme Court earlier today. The conservative supermajority, which includes 3 of the justices handpicked by Donald Trump himself, overturned a 40-year-old precedent, taking aim at the power of federal agencies to function. The Chevron ruling, as the SCOTUS blog puts it, quote, cuts back sharply on the power of federal agencies to interpret the laws they administer, and ruled that courts should rely on their own interpretation of ambiguous laws. The decision will likely have far-reaching effects across the country, from environmental regulation to healthcare costs. Today also saw the court rule in favor of the January 6 insurrectionist who challenged his obstruction of official proceeding charge. That ruling, which we will dive into a little deeper in a minute, could have an impact on hundreds of other January 6 prosecutions as well. And there's still more to come from this highest court in the land. The Supreme Court has indicated that on Monday, that'll be their final day, and on Monday we will find out just how extreme this court really is when it releases its final decision on Donald Trump's claim that a president should be immune from prosecution. It will be a momentous decision. We'll see if this court believes that Donald Trump, or any president, is above the law in the United States of America. It's where we start the hour with some of our favorite experts and friends. Senior editor for Slate, host of the Amicus podcast, Dahlia Lithwick, is lucky for us back with us. Also joining us, the executive director of Fix the Court, Gabe Roth, and former top prosecutor at DOJ, MSNBC legal analyst, Andrew Weissmann. So, For you wonks, I know Chevron gets shorthanded. I need someone to sort of take me to school. Dahlia, can you just remind me what this decision is and what their opinion does?
Maybe I would just say this, that ultimately I think that watching the sort of horse race of last night's presidential debate is, in fact, a conversation about stakes. Chevron is it. Chevron is real stakes. And if you look at what the Supreme Court did today, I think it's fair to say that whatever horse race is going on in the presidential contest, there's like a tank division moving in that's going to change the way we all live our lives, regardless of who wins the horse race. So Chevron is essentially shorthand for a longstanding tradition that says that if there's an ambiguous statute, the courts defer to the agency itself and their interpretation of how to read that statute. Why? Because agencies are teeming with people who know science and who understand how the climate works and who understand how healthcare works and who understands how guns work. And essentially what the court said today is, nope, from here on in, we're going to arrogate to courts the power to decide how agency regulations are interpreted. And I don't want to be in any way alarmist about this, but this is a wholesale transfer of power over federal regulatory agencies. Clean water, clean air, guns, healthcare, monetary policy, all of it is shifted now away from federal agencies and into the laps of courts. And I think the last very, very cynical thing I'm going to say is that the Supreme Court can't even control its own website this week, downloading, uploading opinions before they're ready to go. It is hard to understand how they can have the kind of expertise to talk about nuanced things like climate and healthcare if they can't even sort out their own in-house procedures.
Well, it's a pretty profound point. I mean, it sounds small, but it gets to the essence of what this decision does. I appreciate everything that you said, and especially this contrast and this warning almost to be careful if you dabble in horse race analysis, because nothing less than the future of our government to function is already on the line, is already at stake. And I would, the only thing I would say is you're not being alarmist, but Justice Kagan certainly was. Let me read from her dissent. Quote, "In one fell swoop, the majority today gives its exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. As if it did not have enough on its plate, the majority turns itself into the country's administrative czar." That is an alarm, the likes of which I don't know that we've seen this term. Dahlia.
The other thing I would just point out that Justice Kagan does, and this is familiar to those of us who remember the dissent in Dobbs, is her dissent here is really a cri de coeur about what it means when the majority willy-nilly reverses precedent without doing so carefully, without thoughtfully assessing what it is that's happening. And, you know, we've talked so much in the last months about the need for stability and predictability in the law. And what she's warning, in addition to this kind of wholesale power grab by the courts that I think, frankly, you're right, terrifies her. I think the other thing she's saying is every precedent is on the line. This is now a decision that if it gets 5 votes, precedent is gone. And again, we have organized our lives for 4 decades on the proposition that this is how government works, that regulatory agencies should feel free to try to do their best to regulate complicated social problems, and to have that just go away in the blink of an eye without much understanding of what it is to reverse that precedent is almost the most chilling part of this for Justice Kagan.
Andrew Weissmann, let me read a little bit more of what Dahlia is talking about. This is from Justice Kagan's dissent. Quote, "It barely tries to advance the usual factors this court invokes for overruling precedent. Its justification comes down in the end to this: courts must have more say over regulation, over the provision of health care, the protection of the environment, the safety of consumer products, the efficacy of transportation systems, and so on. A long-standing precedent at the crux of administrative governance thus falls victim to a bald assertion of judicial authority. The majority disdains restraint and grasps for power." Wow, I've read that now 4 times, only out loud twice, and that feels like that just feels so profound to me. The majority disdains restraint and grasps for power.
Well, Nicole, as somebody who understands sort of what Republicans in this country used to stand for, that's what's so remarkable here. Because the court is supposed to be a body, according to Republican orthodoxy, what used to be Republican orthodoxy was restraint of the courts because it's viewed as a sort of anti-democratic check. And that is what she is saying it is not. In some ways, this is a real wake-up call from last night because it tells you, if you didn't know this from Dobbs, you know this from this decision, that the Supreme Court is so on the ballot. For those of us in the legal field, it's hard to stress enough what Dahlia is saying, because it's not just that this changes the fundamental way in which the courts have dealt with the administrative state, certainly at least since FDR, but it also, because of the complete lack of respect for precedent, it just signals that this court is willing to do to Chevron, to Roe versus Wade, and And if it goes forward in a Trump 2.0, like everything's on the table. And that is the message from the decision today, more than any of the cases that we've seen this term. This is such a clarion call for why it is so important for people who disagree with what's going on to get to the ballot box and to really think about the Supreme Court in the way that Republicans for decades have thought about the Supreme Court being a fundamental institution they wanted to change.
I mean, Andrew, what uncorks this? I mean, all of them, did they lie in their confirmation hearings when they described precedent and super precedent? And if you're not a lawyer and you're not a Supreme Court watcher, you barely understand that, but you think it means they won't touch things that have been there a long time. What uncorks them and turns them into this really, really active, agitated, sort of burn it all down body?
You know, I don't know, and I also don't know if there's an answer for all of the justices. You know, I think that there's an answer for Alito and Thomas that may be different than Amy Coney Barrett and Chief Justice Roberts. And the reason I sort of single out Amy Coney Barrett is she has issued some fairly interesting decisions in the last couple of weeks. Indeed, we're going to talk about the obstruction decision, and she actually writes the dissent. And so, you know, you do get the sense of a mind that is thinking and that is not just a knee-jerk reaction to side automatically with what Justice Alito is going to think. But I think for Justice Alito, he is leading a charge of that is very much a sort of what I would call a MAGA justice. It seems so unthoughtful and so untethered to the facts, and a complete disrespect for decades of other jurists, as if the other people who served on the Supreme Court were a bunch of bumpkins.